So the federal Ninth Circuit Court of Appeals has come out with a gun case, kind of. What's going to be really interesting, what you will get out of this case, is how someone turned kind of a traffic stop into a felony arrest against himself. And we cover everything from Terry stops, reasonable suspicion, probable cause, detainers, you name it. There's actually a lot of interesting things that happened in this case, which happened to involve a gun. And I figured, you know what? People seem to like it when I talk about this kind of stuff. And there's lots of important things in here. So it's a great case to walk through it. So guys, let's get into it. All right, so this is happening in Nevada, specifically Las Vegas, in the Ninth Circuit Court of Appeals. This involves Mr. Larry Seng-In, S-E-N-G space I-N. I apologize if I'm mispronouncing anything. I'm gonna call him Mr. In. So Mr. In was both illegally parked and had a broken taillight near the Las Vegas Strip when 3 officers noticed him while they were on bicycle patrol. That's going to be important, bicycle patrol. While one officer made contact at the driver's side window and asked for his license, another spotted a Glock handgun laying on the rear seat floor passenger side. So it's kind of like if I'm the driver, if I'm going to put something behind me, I'm going to put it behind, generally speaking, at least this is me, the passenger side seat on the floor. I guess you could try to do one of these things, but at any rate, that's where it was, over there on the passenger side floor. Now, immediately officers asked him to put his hands up and not to reach for anything because, again, one of them had the flashlight there looking at the gun. So plain view, eyes on gun. They promptly opened up the driver's side door. The officer reached in, unbuckled him, and out comes Mr. In from his car voluntarily. There doesn't seem to be any issues here. So what's going on? One of them is officer safety. This does come up, and it comes up a lot, not only in this case, but other cases. And a lot of people don't really know what this is. Courts give officers, oftentimes, an enormous amount of latitude. Sometimes a lot, depending upon your jurisdiction, sometimes less, but always a fair amount, depending upon the state and jurisdiction that you are in, to take actions that may otherwise be a violation of someone's right in the name of protecting officers' lives. This is one of the examples of that. By taking Mr. In out of the car, the officers are creating a detainer as well. Now, the law protects people from unreasonable searches and seizures. The same is true of detainers. You can be detained, it just has to be reasonable. You can be searched, it just has to be reasonable. Doesn't protect you against any search or any detainer. So the question to determine whether the detainer is legal is whether or not it was reasonable under the law. Now, broadly, there's really no, and this will drive some of you nuts if you're from a STEM field, if you're an engineer, if you didn't major in some sort of bachelor's of arts, if you went to college or something like that, this is going to drive you nuts because this is a very esoteric discussion. There's no strict formulas with points and all that kind of stuff. It's an exercise in poetry deconstruction. And I'm not defending that. I'm just saying buckle in and get ready for that. Broadly, courts will see how burdensome was the detainer. Were you detained for hours or were you detained for seconds? And what facts prompted this detainer? If a detainer lasts too long, it may turn into a de facto arrest. In other words, it may turn into an arrest whether the officer is considering or warning that it is an arrest. A court may later on basically kind of upstroke it to say, nah, you detained the guy in the back of your squad car with handcuffs on for 4 hours. That was a detainer. That's an extreme example, but you get the idea here. Hey, really quickly, 2 things. Number 1, if you're enjoying this video, of course, all the YouTube things, please consider giving it a thumbs up. Number 2, we've got a sponsor for this video, and that's my law firm. It takes me, I think, as you can guess, a fair amount of time to research for these videos, put them together, come and film them, all that kind of good stuff. Not to mention Derek, our brave videographer and editor, who is, of course, working full-time for the law firm to come in and do all that kind of good stuff as well. So something you can do if you're enjoying our legal education content is please consider giving our Google My Business page for the law firm a 5-star review. It's something that really helps out the practice, which at the end of the day allows me to come here and play internet lawyer for you. So It's absolutely free, takes a few moments. Just check it out in the pinned comment below. It's also in the description box. Follow the link. It asks you to rate us on 0 to 5 stars. Keep in mind, this is the internet. 3, 4 stars, kind of a failing grade. So if you felt like you get good, decent legal education content, please consider leaving a 5-star review. I appreciate it very, very much. Now back to the program. Now keep in mind that arrests require a higher legal standard of evidence, probable cause. Detainers and a lot of kind of roadside sort of stuff just gets to reasonable suspicion. Reasonable suspicion, we're talking about reasonable articulable facts that an officer can put there that go beyond a mere hunch. Reasonable suspicion. For an arrest, you need probable cause, much higher. So if an officer lacks enough evidence to establish probable cause, then the detainer that may be turned into an arrest may become illegal. Why? Because the officer may have had enough reasonable suspicion to detain them, but not enough probable cause to arrest them. The effect can be that maybe if the officer found something illegal, or the defendant made some sort of on-Mirandized statement, or there's some sort of search that happened that could have been illegal, may have been illegal, under a normal detainer, it could then become illegal once the officer arrest takes place, according to a later court, and therefore, hey, basically the chain of evidence may have been severed and everything that comes downstream of that now de facto arrest could become suppressed. So that's all very, very important. Now, well-trained officers are very aware of this fact. There's a clock that's kind of ticking in the back of their heads. They're taking a look at the circumstances. They need to be constantly framing in to look at the evidence, what's going on, framing back out to do those mental and those gut checks about, do I have enough to keep going? Where is this going? And all that kind of stuff. And officers learn this on the force and all that kind of stuff. And they learn it, of course, at the academy. Now, practically speaking, if officers, as a result of all this, misplay their hand, it often turns into case dismissed. If there ever is one, of course. As one court said, that being the United States Supreme Court in 1985, U.S. versus Sharp, something to the effect of this: at some point, a stop that's investigative in nature can no longer be justified as an investigative stop. And it winds up turning into an unconstitutional and illegal de facto arrest. That's going to be important because that's going to be the major defense in this case. Let's keep going on with the facts. In this case, the initial stop could be for probable cause because, after all, we had at least 2 traffic violations. We had both illegal parking as well as a taillight issue. An officer also added that Mr. In was parked for too long, giving rise to the possibility of a Terry stop. Now, if you hear an officer say something like this, oh, you've been here for too long, you've been there too long, all that kind of stuff, what they're doing is they're putting their foot in the door to possibly raise a Terry stop issue. Terry, T-E-R-R-Y. You've probably heard this before, but you may not exactly know what's going on with it. Let's do a quick dip into Terry stops. A Terry stop, named after the United States Supreme Court case Terry versus Ohio from 1968, is a stop that allows officers with enough reasonable suspicion, which again is less than probable cause, to make a stop and to do, for instance, an over-the-clothes pat-down for weapons for officer safety. And then, of course, they could be asking you questions and all this other kind of stuff. In that case, Terry versus Ohio, the Supreme Court basically addressed that police officers can only stop a person if they have specific, reasonable, articulable suspicion of criminal activity. So, for instance, in that case, there were 2 guys that kept circling a block, and they looked into a storefront more than 20 times. I think it was 24 times. Now, officers saw this, and they said, this is a little bit more than casual window shopping. It looks like they might be casing the store for a break-in, for a burglary or something like that. Now, officers wound up following the men, subsequently stopped them, and they did an over-the-clothes pat-down search of their outer clothing. The court held, this is the United States Supreme Court in 1968, the court ruled that this limited stop and frisk for weapons was reasonable to ensure officer safety, and as a result, this type of investigative stop, because of the case name Terry versus Ohio, would later become known as the Terry stop. Now, it's only justified by reasonable facts that basically point to suspicious conduct to form the belief of possible criminal activity. So this goes well beyond just some sort of mere hunch or anything like that. Okay, so that's a quick dip into Terry stop. Now back to Mr. In, who we left off as still being roadside in Las Vegas. So Mr. In is asked whether he has any weapons. He says, no. Brilliant, right? I don't even know what to say. If you're gonna lie, I guess at least make it a good lie. To be clear, that's not legal advice. But I mean, come on, man. Like, your gun was in plain view. One officer, the one that was checking things out on your passenger side, says it to the other officer. I don't know if he heard it or whatnot, but that's like every episode of Cops. For those of you who are old enough like I am to remember the show Cops, where it's like the cop pulls over the guy and, you know, he finds drugs in his sock and the guy's like, oh, these aren't my socks. These are my cousin's socks. It's like, what are you supposed to say to that, right? So the guy says no. Mr. In says, no, I don't have any guns. Now, with the Glock already in plain view, it's time for the handcuffs to come out. Now, keep in mind, Mr. In is already outside the car. I gather that he's basically leaning against, I think from the case, it was the driver's side rear door. And if he didn't already have those handcuffs coming, the lie definitely put it on at this point. Now, kind of a funny exchange happens at this point. The officer involved, Officer Anderson, says, quote, why is there a Glock back there? You don't know now? End quote. The defendant, well, he just said that, well, look, I just left a shooting range. Okay. Doesn't really get around the lie. But he's trying to create a reason for why there's a gun in the car, you know, laying out uncased in the back seat. Okay. Or on the floorboard, right? The other officer, Officer Diaz, responded, did you? In some sandals? Do we look new to you? I can just picture that. Like, post up in the comment thread, do you go shooting with like your bare feet hanging out in sandals? Because you probably, that feels like a mistake you make only once if you're going to, especially an indoor shooting range where brass is going to clink around and all that kind of stuff. Now, I don't know if Mr. In was claiming he went to an indoor versus outdoor shooting range and all that kind of stuff, but I understand the immediate pushback. Now, given that Mr. In was already caught lying, he denied having a gun while officers are literally staring at it. This then leads to the officers to suspect that maybe he's also lying about, hey, you know, they asked him, are you a prohibited possessor? In other words, are you a felon? And he said, no, of course I'm not. Imagine their surprise when it turns out he is a felon. And under Nevada law, he was committing a felony by being in possession. Now, as we've talked about in this channel here before, a lot of those laws challenging the felon in possession of a firearm for being unconstitutional under the Second Amendment, they might be changing or going away in some way, shape, or form. But for right now, this continues. So the officers then have a brief exchange where they're talking about whether or not did they grab the gun. This gets interesting again. Now they've got some choices here in kind of the officer at the scene decision tree. They could say that the item is in plain view, which is a recognized warrant exception. So generally speaking, you need to have probable cause in order to get a warrant. Okay, anytime you're doing any kind of search. Now, there's a whole host of exceptions to warrants. For instance, exigent circumstances. If you're outside a bathroom and you know that there's a whole bunch of cocaine in that bathroom, just hypothetically, you know that, and the toilet keeps flushing, okay, that probably is exigent circumstances for destruction of evidence, right? So that's one example of an exception to the warrant doctrine. Plain view being another. If I'm in a place, if I'm a police officer, I'm in a place where I'm allowed to be, and if I see contraband, something illegal right there in plain view, I'm not like searching and rustling through stuff. I just see it hanging out on a table or something like that, and I'm lawfully in that house. Guess what? That's now mine. They could go with the automobile exception under the Fourth Amendment, which we've documented in detail here before. This is one that I'm not particularly fond of, and I'm not endorsing or going against these. Automobile exception, basically the courts have ruled that you have a lower degree or a lesser degree for an expectation of privacy when you're in a car, when you're in an automobile, for a variety of different reasons. So that's the gist to it. We call that the automobile exception when you're in the criminal justice system. Doesn't mean you have none, just means you have less. They likely cannot go with officer safety, given the fact that there's no other occupants in the car, at least none that were discussed, and the only suspect, now suspect, on the scene is handcuffed outside of the car with seemingly no way of getting inside. So you can't really go with officer safety. Now, I've also seen so-called inventory searches be misused to produce evidence in these sorts of cases. An inventory search, really quickly, is where if the officer knows that they're going to be impounding and towing a car, they don't want to be accused, maybe even sued, for having valuables taken from it. So, under the theory that I'm just conducting an inventory search, I get to now search and inventory the whole car. Now, I say that misuse, and maybe I've seen this a time or two before, because I've seen, I can't even tell you how many times officers will inventory a search not looking for anything other than contraband, anything other than something illegal. And once they find it, yeah, they'll keep searching around, but there is no inventory. And I've seen clients who legally were in possession of tens of thousands of dollars of tools and other valuables. Not a single record made about any of those tools or valuables as the vehicle is going into impound. So, maybe not all bona fide inventory searches, if we're being honest here, right? I feel like we can be honest with each other, right? Okay, good. So they could also go for search incident to arrest. Now, really quickly, the game up until 2009 for law enforcement often went like this, particularly if you got a bunch of people in the car. Find a reason to stop and ID and arrest anyone in that car, and then you could basically search everyone and the inside of that car, incident to arrest. In other words, I arrested someone, I can now search the other people inside the car and the car itself, incident to that arrest. The United States Supreme Court shut that down in Arizona v. Gant in 2009, and as a result, the game has kind of changed. Now, the theory for Arizona v. Gant is that law enforcement officers can search automobiles following arrest only if the person arrested could have had access to his car at the time of the search. In other words, if the person that was arrested could somehow, some way, reach into their car for a weapon, then the search could be based on search incident to arrest because there's an officer safety exception. As we see in law, okay, so that really reset the Fourth Amendment from down here of like someone had overdue library books, there was some sort of municipal warrant, tag them if you can, now you can toss the car, and really raise the Fourth Amendment back up here. And then what happens is it kind of gets whittled down over time. And we're closer to this end than we were to that end about 15 years ago in 2009. So ultimately the officers say, you know what, let's just be safe. They do a telephonic search warrant. So basically an officer gets on the horn, they talk to a prosecutor, and they wind up getting a search warrant. They swear to it over the phone and all that kind of stuff. And it gets issued, then they go and they get it. The trial court judge ultimately winds up dismissing the case, not on Second Amendment grounds, as I said before, but because the defense successfully argued that the handcuffing of Mr. In escalated the Terry stop, that's a temporary stop, into an arrest. California, back in the day, and I'm sure other states too, used to basically have a bright line rule saying that if someone's handcuffed, it's an arrest. They were overturned in this case. Again, that's no longer the case, just so we're clear. But notions of this linger out there. Echoes of it linger out there sometimes. The Ninth Circuit Court of Appeals overturned this. Ninth Circuit Court of Appeals, by the way, is between 50 to 65% filled with Democratic appointed judges. I'm not saying that as a pro or negative, just giving you data points. They reversed this dismissal and reinstituted the case against Mr. In because they said that the handcuffing was reasonable on 3 grounds. Number 1, when Mr. In lied, he, quote, raised the possibility that the stop could turn extremely dangerous due to the information gap that existed between the officers and Mr. In and the unsecured gun on the floor of the backseat of the car, period, end quote. So anytime you have a firearm in this situation, one of the takeaways you need to have from this is if you lie about anything, Mr. In is in handcuffs outside the car. How in the world is he going to get back into that car? And he's already had an over-the-clothes pat-down for weapons. Just the same, that handgun in the backseat of his car that he has no ability to access is still being used against him. For those of you who are going around transporting firearms or carrying firearms, if you make law enforcement aware of the fact that there is a firearm, and if you lie or are wrong about something, you can see how this can all stack against you fast. Number 2, the stop was 50 feet from the Strip, which, as we all know, is a very densely populated tourist area. So basically the courts gave him extra leeway for safety. Again, given the fact that the firearm's present. If you're in popular retail or urban corridors where there's lots of people, absolutely. Firearm can absolutely change your Fourth Amendment. You see it right here. And number 3, no squad car, because we're talking about cops on bikes. So ordinarily they can kind of just throw you in the back of the squad car, kind of warehouse you back there while they're talking and figuring out what they want to do. Wasn't an option here. We've got 3 officers on bicycle patrol. So that's not even a decision Mr. In made, but once more, that changes the facts and it changes the application of law. I hope you found this illustrative, because if you go about transporting, carrying firearms, and if cops learn about them, you can see how this case perfectly illustrates how that really, it's like dropping a boulder into a river, and you could see the course of the water change as a result. So I hope you got something out of that. Let me know down in the comment field below if you did, and if so, what you found to be most interesting. Hit that like button if you've not already done so, and now let's close out with our ever popular quote of the day. This one comes from one of my all-time favorite authors, J.R.R. Tolkien, who once said, quote, "Never laugh at live dragons," end quote. It's one of the reasons why it might be fun to poke fun of institutions and groups that we may not like. But if they've got power, either now or in the future, be careful. Be very careful, because that's a dragon. Looking forward to reading the comments as always, and I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.